Good morning to one and all. I, Ritupriya Gutu, on behalf of Department of Law, Prestige Institute of Management and Research, welcome you all to the special webinar on law and justice. We are delighted to have amongst us Latika Vashisht ma'am. She is an assistant professor at Indian Law Institute, New Delhi, and she has graduated from Faculty of Law, Delhi University, and pursued her LLM from Indian Law Institute. She has also completed her PhD on the topic Law, Feminism, and Emotion, working through legal consciousness. Her area of interest includes feminist legal theory, criminal law, and psychoanalysis. We welcome you, ma'am. I request Latika, ma'am, to kindly address the gathering. Latika, ma'am, over to you.
Yeah, thank you so much. Am I audible? I just want to make it. Yeah, okay. Okay. Thank you so much, Professor Ritupriya, for that very warm introduction. Before I start, I really want to extend my gratitude for this invitation. When I got a call from Professor Kamlesh Jain, I was very thrilled, and I really wanted to speak to the students. So thank you, Mr. Jain, Mr. Nakul Singh, Professor Ritupriya, Dr. Nishant, for getting in touch with me and getting this planned. I'm very happy to be here. I was told that I will be interacting with students who have just joined the fresh batch of LLB, BA LLB, and BBA LLB. So a big hi to all these students. And I'm sure you have joined this institute with a lot of enthusiasm about the discipline of law. You're really passionate about it. That's why you are here in studying law, trying to explore different legal areas. And because I'm assuming that you are interested in law, the next assumption is going to be that you're all interested in the question of justice, because law and justice are intrinsically connected. It's very difficult to imagine one without the other. So today I'm going to take your time and speak about these two concepts. Now, just give me a minute. I'll just share my screen so that you can see some slides that I've prepared for you. So here it is. Yeah, is it there? Can you all see this? Yeah, sure. Yeah. So as I was saying, that I'm going to talk about these two concepts, which are foundational, I think, to the lives of the students who have joined this institute. So what I'm going to do in the next few minutes, around 30 minutes with you, first of all, I'm going to try to talk about the relationship between these two ideas, law and justice. And this relationship, I must tell you, is not an easy relationship at all. Like all relationships, including romantic relationships, it is a relationship of struggle. It is a relationship in which we really have to work hard, right? It is almost a relationship of love and hate. Okay, so this is what we are going to see, in the next few minutes when I talk to you. When I say that it is a relationship of tough love, what I actually mean is that the complexity of imagining law and justice together has to be taken on board, and anyone who is trying to learn different manifestations of law in our life. Okay, and we cannot understand one without the other. So these two concepts have to be understood together. But at the same time, we have to understand that how in being together, their togetherness is a very difficult thing to accomplish. It is because of various factors, okay, which we'll see. In the process, while talking about this relationship, I would start by talking about how laws cannot exist without justice, okay, or the idea of unjust or lawless laws. Okay, so and this has been a very long standing debate in jurisprudence. For the longest time, jurists across the world have debated the idea of existence of law without the component of justice. Okay, and we'll try to see that whether we can call a law a valid law if it does not have the component of justness. right? We will also talk about justice without law. Can there be such a thing? Can we imagine a society which does not have a body of rules, which is devoid of law, where there is no legal system, and then can we talk about justice there? Or would this kind of justice without law be nothing but an anarchist situation? Okay, this is also we are going to discuss today. So let's get started. Let's actually start with the very basic thing. What is law? In the next few years that you're going to spend in the law school, this is one concept that you will struggle with because it's so difficult to define these expressions, right? Law as well as justice. I mean, it's very, very difficult to give them a definitive meaning. It really depends which school are you coming from? What is your worldview? And then depending on your worldview, depending on your orientation, depending on your school of thought, can a definition be attributed to law. But very generally, if we have to give a very, very general meaning to what is law, it is this. It is a system or a set of enforceable rules to regulate behavior. And who enforces these rules? Sometimes, mostly, when we talk about law, when we think about a legal system, we're thinking of formal legal system where state institutions are duty bound or are given the task to enforce this system or these rules. But at the same time, we know that we also have informal legal systems where non-state institutions can enforce unwritten rules, customary rules, right? So when we're thinking about law, we cannot just restrict ourselves to imagining formal legal systems only. Informal legal systems are also have that kind of power, okay, which a formal legal system has, right? They can also have, they also have their own set of rules, which may not be written, but they are customary, they're long-standing, unwritten rules. They also have a system. And these rules are meant to regulate people's behavior, right? So all these ingredients which we talk about when we talk about law are present in informal legal systems and which are backed by non-state institutions like panchayats, right? So in our understanding of law, we have to keep that in mind, that we cannot just restrict ourselves to formal legal system. Now let's come to the next term, which is going to be our focus, which is justice. What is justice? Now, justice is another idea which is extremely difficult to pinpoint, that this is justice, okay? Biggest scholars of the world, really, really renowned scholars of the world have really not been able to give us a clear definition of what justice is. Because justice is a matter not just of understanding, it's often a matter of perception. How are you perceiving things? It's also a matter of feeling. Do you feel, have you felt that, justice has been done in a situation? Very often, and you must have seen this, very often, the formal legal system, the courts may have delivered a decision, but the litigants do not feel that they have got justice, they've got closure, right? So justice is not just a matter of enforcing or implementing what is written in the statute book, right? It is also sometimes not a matter of sending someone to jail, because that might not really feel like justice, right? So we really have to understand that, again, the simplistic cause-effect relationship cannot be transplanted to law and justice relationship. That if we are going to implement law, automatically we are going to reach justice. It's not that simple at all. Okay, and we can talk about it later, in the Q&A session, but I'll quickly move on now. When we talk about justice, let's do it. Let's try to see, when I was saying there can be different concepts of justice, different understanding, different perceptions of justice, different feeling about what is just, what is not just. I'll take an example, and this example is from Amartya Sen's book, The Idea of Justice. Anybody who's interested in jurisprudence, legal theory, and in fact, all law students should actually at some point in time pick up this book, and try to see how Amartya Sen is trying to interrogate, this very, very difficult concept. But in the very beginning, in the very introduction on page 12, he gives us this very interesting, very sweet illustration of 3 children and a flute, basically to drive home the point of how justice has different understandings, right? So what is he talking about? Through this illustration, what is this illustration? He says that there are 3 children, Anne, Bob, and Carla, and they're quarreling about who should get a flute. Okay, kisko bansuri milni chahiye. And the answer to this question, okay, so this is a question of justice. Okay, that who's entitled to one flute. There's only one flute and all 3 want it, but who's going to make the best claim, the more just claim to get that flute? And all 3 children, they're very smart and they come up with their own arguments, right? And what does she say? Anne says that I should get the flute because I am the only one who knows how to play it. Okay, the other 2 don't know how to play it. So it would be very unfair to deny the flute to me, who actually knows how to play it. To the other 2, it is going to be totally useless. They would not even know how to use it, right? So I should get the flute. Bob, who's the second child, he says that no, I should be entitled to it because I'm the only one who doesn't have any toys. I have no toys at all. So it doesn't matter if I know how to play the flute or I don't know how to play the flute. What matters is that at least I get my first toy. And unlike Anne and Carla, who have many toys, I have none. So I should be entitled to get the flute. Carla makes a very different point. She says that I have made this flute with my own labor. I worked for months and years and then I made this flute. And just when I finished it, these 2 have come and now they want that they should get the flute. This is very unfair, she says. Okay, so she complains that these expropriators came along to try to grab the flute away from me, which is something that I had made using my own labor, right? So these 3 smart children are giving their own understanding, their own understanding of their particular situation, and then they're making a claim right to this flute, right? So you will also notice that they're all, if we actually think about it from the perspective of justness, okay, or just result in this particular case, if somebody has to decide who should get the flute, all 3 of them are telling us that justice is plural. They're plural and competing and conflicting views of justice, right? They cannot just be one strict meaning that can be attached to what is just. So what does Sen basically say? And this is a quote that is from this book where he says, and I'm going to slowly read it. Please try to follow it with me. He says, at the heart of the particular problem of a uniquely impartial resolution, okay, of the perfectly just society, where we have to be impartial and we have to ensure that the society is perfectly just, is the possible sustainability of plural and competing reasons for justice. Okay, there are diverse reasons, multiple reasons for justice competing. They're in conflict with each other. Only one child would get through, the other 2 would not. Okay, all of which have claims to impartiality and which nevertheless differ from and rival each other, right? This is the point Amartya Sen is trying to drive home, that even when we claim to be totally impartial, even at that moment, we will see that in a society, because people come from different backgrounds, people have different orientations, different perspectives, they have their different worldview, right? The notion of justice that people are going to have are going to be different from one another. We cannot have a homogeneous view of justice. So, but let's try to understand what are these different notions. If we actually try to understand the claim that was made by Anne, okay, which on the screen I've depicted by A, okay, child A, who is Anne. She is talking about, what did she say? Anne basically said, I know how to play the flute, so I should get it, right? So basically she's talking about maximum pleasure, that I'm the one who would get maximum pleasure from this flute because I will play it, the other two won't. So Anne is talking in terms of a theory of justice which is known as utilitarianism. Okay, what is utilitarianism? The founder of this theory, Jeremy Bentham, talked about the fact that in a society, one must strive for maximizing utility, and which is by maximizing pleasure and minimizing pain. Okay, so who will get? So Anne's claim can be put into this kind of bracket that she is talking about maximum pleasure. But I will derive maximum pleasure. That is why I am entitled to the flute, and that would be justice, right? If we move on to B, who is Bob, what was Bob's claim? Bob was saying, I don't have any other toys. These two have so many toys, I don't have any. That is why I should get this. Okay, so Bob is talking about reducing economic gaps between them, right? He's using the language of distributive justice. That justice demands that it should come to me because I need it more. These two already have more toys, right? So he's using the language of this, and we see, and why am I telling you all this? Because in the society, you will see different claims of justice being made in these languages and these theories only, right? See, Carla, what was she saying? She was talking about enjoying fruits of one's own labor, right? I'm the entrepreneur. I made it, so I should be left alone. It should be given to me, right? So she's talking like a libertarian. Okay, that I should not be disturbed. I don't care who has it or who does not have it. I made it. That's why I'm entitled to it. Okay, so with this very little small example, Amartya Sen has told us that has basically taught us these three theories of justice: utilitarianism, distributive justice, and libertarianism. Okay, and one can say that they are all in their own right. All three are right. Okay. But we have to acknowledge that they are conflicting claims. Okay, they are competing claims. As he says on page 15 of his book, the three arguments each point to a different type of impartial and non-arbitrary reason, right? Also, please remember what kind of society that we will have depends a lot on what notion of justice, what kind of theoretical framework of justice our decisions are informed by. Do we take pleasure more seriously, or are we interested in reducing economic material gaps in our society, or we are interested in advancing entrepreneurship? What is it? And I would say that all students should look at part 4 of the Constitution from this lens. I mean, I think it will be very interesting to see part 4, which talks about directive principles of state policy, what kind of orientation of justice is embedded in part 4? What kind of state policy should be adopted by the Indian state? Right. So what have I told you till now? I've talked a little bit about what is law, and I've told you that how justice is a very, very difficult concept to define, and different theoretical frameworks give us different understanding, different positions on justice. Right. I'm hoping that you're all with me till now. Now let's move to the next phase. Now, where I want to talk a little bit about law without justice. Is law really law if it does not have a component of justice? Can we talk about law, which is, can we say that an unjust law is valid law? And for this, I want to take you to a Greek tragedy, which is by the name of Antigone, which was written by a Greek philosopher, Greek playwright Sophocles, as long back as 441 BC, right? But before I actually go into this, I also want to tell you that law and justice could be a very, very theoretically dense discussion around jurisprudence. In my talk today, I have tried to stay away from it because I was very conscious that it is not a class of jurisprudence. So I thought that I'll talk more about stories, I'll talk more about literature, popular culture, films, etc. Okay, so this is what my presentation is going to be about. I'm just warning you beforehand, right? So let's go back to Antigone, which was written by Sophocles. What is this amazing, amazing play all about? Antigone is basically about, so let me just tell you a little bit about what the play is and then the main question that the play poses. And this question has been taken up even today by all philosophers, I would say, of the world, right? They all have written on Antigone, tried to struggle with the questions that Antigone poses to us. So what was this play all about? It starts with this background. There are two brothers, Eteocles and Polynices, who die fighting each other in a civil war for the throne of Thebes, okay, which is the city of Thebes, right? So there's a civil war and they are fighting on the opposite sides, and both of them die. After their death, the new ruler is instituted in the city, whose name is Creon, okay? And what Creon does is he wants that, okay, civil war has just happened. So he wants that now I've come to the throne, I want to restore order. So how does he restore order? He passes laws. And one of the edicts basically means a law. One of the edicts he passes is, it is meant for punishing traitors and honoring heroes and shaming the traitors. So what does this law or what does this edict say? It says that Polynices' body will not be sanctified by holy rites. It will not be given burial rites, and it will lie unburied on the battlefield. Okay, so the last rites, or one can say the respect that the dead deserve, would be denied to Polynices. Okay, because according to Creon, he was a traitor. Okay, so he should not be, dead body should not be respected, and it was the harshest punishment of that time. Now, this was a very, very harsh law, and when the sisters of Eteocles and Polynices, the sisters are Antigone and Ismene, when they get to know about this edict, and when they get to know that one of their brothers, his body will lie unburied on the battlefield, they're really, really in a fix. They don't know what to do. Should they accept this law and allow and just suffer the misery of letting their brother be gone without being given basic dignity of burial rites? Or should they defy this edict at the cost of death penalty, right? Should they happily choose to embrace punishment by defying the law and giving respect to the dead body of their brother Polynices? Ismene is not so courageous, but Antigone is. Antigone chooses and defies the law. What happens after that? In the play, this is something that I've lifted from the play, the conversation between Creon, the ruler, and Antigone. Creon says, did you know about the edict and you still dared to contravene it? You knew this is the law and still you went ahead. And Antigone says, yes, I knew that you have enacted this law, but I still went against it because I also knew that this order did not come from God. Please pay attention here. What is she saying? She says, I did not think your edict is strong enough to overrule the unwritten, unalterable laws of heaven. You being only a man. They are not of yesterday or today, but everlasting, though where they come from, none of us can tell. So basically, Antigone is challenging Creon's edicts by saying that these edicts have not come from God, right? They have just been enacted by you. Okay, and she's making a distinction between laws of God and laws of men. And what are laws of God, laws of heaven, who are unalterable. They can't be changed. Okay, and they are unwritten. And they will overrule any law of man, which appears unjust. Okay, so what is Antigone talking about? As I said, she's making this distinction between two kinds of laws, divine laws and man-made laws, and she's placing divine laws at a higher pedestal, right, as compared to laws made by man. When you will study jurisprudence, you will see that this debate is at the heart of the debate that has been going on for the longest time between positive law thinkers and natural law thinkers, right? Positive law thinkers who would say law is something which is, like Austin would say, law is the command of the sovereign. Okay, natural law thinkers would constantly insist that no, law is not just the command of sovereign, but law has to have a component of morality in it. Okay, law will not make sense if it does not have any component of morality. The famous Hart-Fuller debate, which happened post Second World War, was precisely around this question. Okay, I'm not going to go into the details of that case, but I'll just of that debate. But I'll just tell you that Hart and Fuller took these very diverging positions, and this debate started by after the Grudge Informers case of 1949 in Germany, in which case a wife was basically a wife who had used a law which was enacted in Nazi times to send her husband to jail. So what was that law? Let me tell you from the beginning. There was a law which was enacted by the Hitler's regime in Third Reich, okay, during Nazi period, which said that anyone who is going to say something bad about or something against Hitler will be prosecuted, right? This was the law. So this wife who wanted to, just go away from her husband, who did not want any kind of relationship with her husband, actually informed the authorities that her husband, when he came back, from his duty in the army, when he came back home, he actually said something very, very harsh about the regime, including Adolf Hitler. And the man was prosecuted under this law. After World War II, after the end of Third Reich, after the regime change in Germany, the wife was prosecuted for using this law in an unfair manner, right? And the court said yes, because that law was and they prosecuted the wife because it was believed that she basically, in a very unfair way, tried to make things difficult for her husband, and the law which she had relied on was unjust law, right? So Hart is very critical of Grudge Informer's case in his writings, and he says that no, that law, even if it was enacted by an authoritarian regime, it was valid law. Even if we could say that it was unfair, still it was valid law. While Fuller says that for law to be valid, it has to have a component of morality in it. And because these laws, which made people spy on their family members, did not have that component of morality, they were not valid laws. Anyway, I'm not going to go into the details of it. You will read all of this in jurisprudence, but I just want to go back to the point that I was making, and which was about law without justice, right? And the question being that for the longest time, starting from Greek mythology to contemporary times, people have challenged the idea that the law can be valid if it is devoid, even if it is devoid of justice. Another two important figures that I want to introduce to you in this regard, who have insisted on the component of justice in law, are starting with Mahatma Gandhi. And I would urge you people to actually closely look at Gandhi's trial of sedition. It is freely available online, which was, the trial which was held on 18th March 1922, where Gandhi was tried under Section 124A, which is sedition of the Indian Penal Code. And we all know that this section still holds. It has not been declared constitutionally invalid. It is still a part of IPC. And Gandhi was prosecuted for writing 3 articles in the newspaper Young India. What did Gandhi do when he was tried for sedition? First of all, he pleaded guilty, and he made a very, very powerful statement denouncing the British legal system. I'm not going to read out the entire thing to you, okay? But I would really, really request you people to go online and actually read that statement, because he was such a courageous lawyer. And he, a courageous lawyer who always respected the legal system, even if he did not agree with it. And why do I say that? See what he said. He firstly calls out on the legal system of the British. He says that it is a system which I considered had done irreparable harm to my country. Okay, so it was totally unjust, right? So he said, I either had this choice that I succumb to this legal system, or I had the choice of letting my people know how unjust this legal system is. And then he says, uh, I'm deeply I'm deeply sorry for the fact that people have become turned violent. He was talking to Chauri Chaura, and therefore to I'm here to submit not to a light penalty, but to the highest penalty that can be inflicted upon me. Right? So he's telling the judge, okay, this is a statement made to the judge, that I want that the highest penalty which this section gives should be given to me, because what I have done, okay, with what I have done is a deliberate crime in law. Okay, but at the same time, what I have done appears to me to be the highest duty of a citizen. Okay, this is what Gandhi basically is saying. Okay, so he's saying, I do not ask for mercy, but I agree that I have violated the law of the land. Okay, I've gone against the British government. Okay, and for that I should be given the highest punishment, right? So I want you people to pay a little attention to it. While he does not agree with that system of laws, okay, while he thinks that that system of British law has done irreparable harm to his country, at the same time he knows, he actually says that I want to be punished under it, right? So this is, and please remember, this is not a contradiction at all. Gandhi at this point in time is basically speaking to the judge, and in saying so, he's telling the judge that if you have to do your duty efficiently, it is your duty to actually accord me the highest punishment. But at the same, and why? Because I really don't believe in the system that you people have put in place, right? And these are the reasons that he gives. He says the law itself in this country has been used to serve the foreign exploiter. Okay, and I've examined all these laws, and none of in my examination, I learned that people who were totally innocent were condemned. What does he say further? He says, Section 124A, under which I'm happily charged, is perhaps the prince among the political provisions of Indian Penal Code, and it is designed to suppress the liberty of the citizen. So what is Gandhi saying? Gandhi is basically saying that this law is unjust law, and that is why, I defied it. Okay, so basically, he's talking about civil disobedience, right? Where you do not accept the existing legal regime, but at the same time, he's not running away. He doesn't abscond. He says, okay, punish me, because I deserve this punishment, because this is what the law of the land says. Okay, I'm telling you this because Gandhi is also giving us an example of existence of laws or law or a legal regime which did not have the essential component of justice. Similarly, another stalwart of Indian legal system and constitutional law, Dr. B.R. Ambedkar, who talked about the lawless laws of Manu. Okay, Ambedkar presents in his writing presents the full horrors of classical Hindu law and jurisprudence, which was based and entrenched in the Varna system. And he denounced Manusmriti as lawless law. Why? Because it made half the humanity untouchable, right? So again, he's talking about those kind of rules which are devoid of any component of justice, right? In this expression, lawless laws. So one must remember that. And this is, for those who don't know, this is what Manusmriti looks like. The offenses, which are offenses like of this nature, hurting a higher caste, taking a superior by feet, reading Vedas, hearing Vedas, how certain so-called lower castes have been punished very, very harshly under the scheme of which was given by Manu, who's treated as the first Lord. Manusmriti is the first law code of our country, right? So, but how Ambedkar points out that this code is basically based on caste hierarchy. It actually almost justifies violent punishments which are imposed only by virtue of people belonging to a certain caste. Uh, with this, I want to basically further explain the idea of lawless law. I want to take you to the writings of Professor Upendra Bakshi. And specifically, he explains this expression lawless law in a lecture the Ambedkar Memorial Lecture that he delivered in 2013 at Ambedkar University, Delhi, where Professor Bakshi says that lawless laws are of this nature. First, where any legal order that inaugurates and perpetuates violent social exclusion, where people are socially excluded violently. Okay, if a legal order is creating these conditions for social exclusion or perpetuating it or allowing it, that is an illustration of lawless law. That legal system is an illustration of lawless law. Secondly, he says practices of violent discrimination against untouchables. These forms of adharmic conduct and practices, like generating constitutive formations of lawless law. Okay, so violent discrimination, which is called adharmic conduct. It is against dharma. Thirdly, he says microfascism of the local, okay, of the low, like microfascism, basically at the local level, at the minutest level, in our everyday, when fascist practices, are practiced and perpetuated. For example, hostile discrimination reinforcing caste apartheid practices. For example, drawing water from a single well, entering public spaces ordained and exclusively reserved by and for upper castes. These are all examples of microfascism of the local, as well as practices of embodiment, as Ambedkar illustrates, such as wearing a shirt or sprouting a mustache. That certain caste, people from certain castes were not allowed to sport a mustache. Okay, they were not allowed to dress up in certain ways. And one must say that this microfascism continues, even after 70 years of of our independence and enactment of the Indian Constitution, despite Article 17. One would find illustrations of lawless laws around us. Again, very, very important for us to understand that the relationship between law and justice is so important. We have to have laws which have a component of justice. Otherwise, legal orders which do not have component, which do not actually focus on inclusion, which do not actually have anti-discriminatory which do not have foundation of anti-discrimination laws, are going to yield nothing but shallow, lawless laws. And I would just take a minute to urge you people to actually look at Professor Bakshi's writing, and especially because I know I'm talking to fresh batch of law students. Professor Upendra Bakshi's contribution has been immense in the field of legal theory, human rights, and you name the field, and he's written on it. So please, I would urge you to look at his writings closely, and people who are interested in looking at the question of caste. Professor Bakshi talks about critical Ambedkar studies movement, which ought to be inaugurated in this country, where we start reading text of Ambedkar critically. But more on that maybe some other time. I will just move on to the next and the final part of my talk today, which is this question: can there be justice without law? Okay, and as I've said, in my view, there cannot be any justice without law. Okay, what is the idea of justice without law? In fact, all of us at some level are fascinated with the idea of justice without law. All our superheroes are based or are created on this idea of justice without law, where there are no rules at all, but somebody with amazing powers, and amazing individual ethics is going to give us justice. Okay, Superman, okay, Batman, all these people, all these popular culture figures are about, are based on this notion that that these figures can give us justice because the legal system at some level is failing, right? The police at some level is not, able to do its job well. That's why we need a superhero who's going to defy all rules, but take us to a more just world. Uh, this is also known as vigilantism, or if I can evoke the philosopher Hegel in this regard, he talks about it in terms of individual heroism. Okay, whether individual heroism, whether vigilantism can actually make our society more just. So what is it all about? And I've put all these posters for you because, as I said, we also have to think about these very, very difficult questions of justice and law and the interrelationship with them, and basically try to find answers in our popular culture too. So I don't know how many of you are really, really interested in superheroes, and whether you watched this film, which was released in 2008, The Dark Knight by Christopher Nolan. It was basically around this idea. It was Christopher Nolan's critique of justice without any law. So this phenomenon of superhero is the phenomenon of thinking about vigilante acts or individual heroic acts, as which are going to take us closer to what we think is justice. Okay, because individual superheroes are beyond all rules. Okay, they don't follow rules which the police force has to follow. They're even beyond laws of nature, right? So they fly. The laws of gravity don't apply to them. Okay, they will fly. They can jump around. They can defy. They have exceptional superhuman abilities. They are almost an exception to law. Okay, where the legal machinery can't reach. If the legal machinery can't give us justice, they will give us justice. So they're exception to law, but they claim that they will give us justice. But please remember, all these superheroes, okay, all the vigilante groups which came to be speaking about justice and which operate outside the law are masked, unlike the police forces, where who wear their badges, right, who actually identify themselves. They're all masked, because if they would not be masked under the legal regime, they would be deemed as criminals. Okay, so this idea also is something that we need to struggle with, because if we really start imagining a world without rules, a world which is set in place by individual or collective heroic exceptionalism, it hardly going to take us closer to justice. It might take us to quick, emotional and retributive justice, कि अभी हम सब चीजें ठीक कर देंगे, अभी हम punish कर देंगे in accused को. Okay, it might take us, but at the cost of dispensation of fair trial and hard-earned due process guarantees, which we have earned with a lot of struggle and which we have placed in a constitution. Presumption of guilt, encounter killings, they're all examples of a kind of disillusionment with a legal system where we think that we can get justice by bypassing the legal system or by going against the legal system. There's so many films, which glorify this kind of imagination, starting from Nasruddin Shah's A Wednesday, Ganga Jal, and so many of, Batla killings and all of them. But I want, as law students, I think we have to be very, very critical of this dangerous idea of justice without laws, because it might give us quick results, but it's totally going to demolish the foundations of our society and the hard-earned human rights that have been put in place in our constitutional framework. So what am I saying in the end? What I'm saying is this, that law and justice, these two ideas, have almost an impossible relationship, which we have to make possible. We cannot imagine one without the other. We can't imagine law without justice. At the same time, we cannot imagine justice without law. Okay. So we have to constantly strive, work towards, and that is what the job of a law student is, and whatever legal profession you choose when you actually get your degrees in your hand, right? That how do we hold on to the justness of laws? Okay, because for us, we can neither be, paid mouthpieces of our clients, nor can we be reduced to uh, uh, technocratic lawyers who will just follow the black letter law without really missing out the component of justness, reasonability, etc. Um, the One of the most important contributions of the Indian Supreme Court has been precisely this. And you will read it in constitutional law that the shift that was made from the case which was called A.K. Gopalan to Menaka Gandhi. Okay, there are these two cases. Is the shift from the technocratic understanding of law to law as law being just, reasonable, and non-arbitrary. And I would urge you again to take this to look at this closely and take this relationship of law and justice. Take this more seriously in your writing, in your research, and in the questions that you pose to your teachers in the classroom. With that, I think I will end my talk.
Thank you so much, ma'am. I think that it was a very enriching session for all the students who were attending, and it was also enriching for me because I got to learn a lot of new things. Ma'am, I request you to kindly stop the screen share, and we'll be moving on towards our Q&A. Yeah. So while you were delivering your address, we had asked the students to post their questions in the chat box, and I'll read out some of the questions to you, and it'll be great if you can answer them. Some of them are kind of very basic because we know that they are first year law students and
Sure.
it's only been 15 days. So we have a question from Mr. Prerit Yadav. Why do we call it a court of law rather than court of justice? Is law really equal to justice?
It's a very good question, Prerit. It's a very, very good question. I think by the end of my talk, you would know my answer to the second question that you have posed. Is law really equal to justice? No. Law is not equal to justice. As I've pointed out, sometimes laws are unjust. Okay, we have unjust laws, and we have to strive and work together, to change those laws. Okay, to get those laws repealed, to redraft them, and to actually to actually transform those laws. Okay, so because law is really not equal to justice. Why we say court of law rather than court of, it's a very, very good question. I had to put my real thought to it, but I would say that even if we call them court of law, the objective of every court of law is to work towards justice, right? So the more apt word should have been court of justice, but we still continue to call them court of law, I think. And I'm just playing around with this question right now, because we know, and not in all cases, the courts actually are able to give us what is justice. Okay, so I think that's a struggle. So it will be too presumptuous for us to call them court of justice.
Okay, I hope that answers your question, Prerit. Ma'am, we have another question from Mr. Vineet Agarwal. His question to you is, ma'am, according to you, what kind of justice does Indian judicial system provide? Is it according to the Amartya Sen book example that you gave?
What kind of justice the Indian judicial system provides? I'm not sure, Vineet, if I understand your question very clearly. By Indian judicial system, you just mean the judiciary, or did you mean the Indian legal system? And what kind of justice? Again, as I said, if we go by Amartya Sen's illustration example, we will have to look at different statutes, different policies, different court decisions, and then analyze in what kind of policies are drafted keeping in mind distributive justice model in my in at the foreground, and what kind of policies are drafted keeping in mind libertarian thinking, that okay, we want to promote business, we want to give the current policies which the government is putting in place to basically give incentives to business to actually uplift the economy. I think it would be very important if we actually start reading that material and finding out, is the government driven by libertarian model or distributive justice? What do the courts actually do when they say, okay, these hundreds and thousands of people who've been living right next to the railway track, the juggies, should be demolished, in 3 months. What kind of perception of justice do they have? Are they talking in terms of utilitarianism, maximizing pleasure? Whose pleasure are they maximizing? Or or are they talking in terms of a model which is that, okay, we are going to promote, we want to promote tourism, and these catos don't look beautiful, so they need to be removed? Because they definitely are not talking about distributive justice if they don't have a good rehabilitation plan in place, right? So I think it is, I would say, Vineet, it is important for us to closely look at every statute. Go to the statement of objects of the statute, look at the preamble of the policies that have been put in place, look very closely, read the judicial reasoning, and try to find out what kind of perception of justice do they have when they actually deliver their decisions.
Thank you for answering that question, ma'am. I hope Vineet, your question is answered. We have another question from Ms. Muskan Tiwari, and her question to you is, how is righteousness different from justice?
Righteousness can be very individualized, right? In fact, self-righteousness is a problem. When you think that only you are right? Justice, as I was saying, it has plural conceptions. It cannot just be about self. It cannot just be about your community. It is sometimes when you have to erode and erase yourself to talk about a larger idea. Okay, you ought to have a larger vision of justice. So righteousness, in that sense, is a very narrow idea as compared to something that is so difficult to define, which is justice. Yeah, Muskan, that's what.
Thank you for answering that question. We'll just take last 2 questions. We have a question from Mr. Swapnil Vyas. It's more of his opinion on what you've said. For providing justice, more weightage should be given to improvement as compared to severe punishment. Is it right?
To for more weightage should be given to improve. If by improvement you mean rehabilitation, if by improvement you mean that we actually work with individuals, and I'm assuming that you're talking about criminal law. If by improvement you mean reformative models, then absolutely, I agree with you that severe punishment is not really going to transform the landscape of the social. What is really required is that we take reformative and rehabilitative principles very seriously, and in all our sincerity, and work with people and find out why people are compelled to commit the crimes that they commit, and what is it that is wrong with the social that produces such individuals who end up committing grave crimes. So I think I agree with you. We have to focus on reformation. We have to focus on rehabilitation. We have to work closely with individuals. And we have to also work to change the material conditions of the society, right? Punishment and severe punishment doesn't really help. It is hardly the deterrent that it is made out to be.
Thank you for answering that question, ma'am. We'll move on to our last question. And this last question is from Ms. Vaishnavi Singh. And this is a common question that they've been asking all the panelists that have come here. What, according to you, are the qualities, skills, and personality traits that a lawyer should possess, a good lawyer should possess?
I think the first thing that a good lawyer should possess is honesty. And I don't, sometimes, and, that the lawyer should be honest. Okay. And when I say this, and I remember saying this once in class. So one of my students asked me, so are you saying that we cannot be a defense lawyer, right? Should we not defend the people who are? No, I'm definitely not saying that. But I think we have to learn we have to actually learn these ethics, that how can we be an ethical defense lawyer when we are actually defending somebody who we know is guilty, right? Or who's been accused of a crime. What kind, how do we actually prepare our defense without slipping into dishonesty? So I think being honest is the first according to me, the most important attribute that a lawyer should have. Secondly, I think a lawyer should read widely. Okay, the lawyer should not shy away from reading and reading closely. Okay, and not just court decisions, but also you know. But also those kind of material, those kind of social science literature, which actually would make us more sensitive to the people around us, right? So I would say these are the essential attributes. You should be honest. You should be a voracious reader. You should try to imbibe as much as possible, because that is going to cultivate empathy in us, which I think is another important attribute that a lawyer should have. You should be able to have that kind of feeling. You should, that you can put yourself in another person's shoes and really, really imagine what that person is going through when you actually represent someone.
Thank you for answering our questions, ma'am. I'll now pass on the virtual mic to my colleague, Assistant Professor Ritupriya Guttu, to take the proceedings further. Thank you, ma'am.
Thank you, sir. Latika ma'am, at the outset, I would like to thank you for introducing the jurisprudential aspect to our students. I personally believe that if one has a good understanding of jurisprudence, then one can really understand what the law can deliver. Having said that, I would like to request Dr. Anil Bajpai sir, COO, Chief Operating Officer of our Prestige University, to kindly deliver a vote of thanks.
Thank you, Ritu. And I will take this opportunity of again welcoming Latika Vashisht, senior advocate, academic in the area of law, a co-alumnus of the Delhi University. Of course, we may be many, many years apart. I was in the 1975 to 78 time frame, and you may be closely associated with a couple of senior classmates, I would say, or schoolmates of mine, the Gupta sisters, Beena and Neena Gupta, one of whom is married to Lalit Bhasin now. And so that's what kept me associated with the law fac, as we used to call it. I was in St. Stephen's, and the DUSU president during our time was the late minister Shri Arun Jaitley. So your erudite and very, very succinct portrayal of justice versus law brought back those memories. Very, very well put. I must admit that starting from the Manu, the lawgiver who cursed his own father, I mean, this is a fable. Many of you may want not to believe it, but it's a fable I've heard, that Manu framed various laws. And one of the laws he framed was incest as a crime. And unfortunately, Brahma, who happened to be the Srishti Rachayita, also created Saraswati. And eventually had to take her as his consort. And therefore, he had committed a crime. And that crime led to Manu giving him punishment that he would never be worshipped anywhere on the planet. So I mean, this is a fable. I have only heard it a couple of times from some people, never found any written evidence to it. But I just want to say that how, whether does law lead to crime, or crime always existed and law just gave a picture to provide justice, to provide some sort of solace to the victim of a crime. Crime happened in in the times of Abel and Cain. Crime happened in the times of Adam and Eve. I mean, at that time, the good Lord decided that if you partook the apple, that would be a criminal act, and He banished the couple from the Garden of Eden. Now, these kind of things, when you go back in history and you go back look into today's, are we really doling out justice the way it should be? The kind of activity that the country is embroiled in. I do not remember, but when Mr. Olok was the Minister for Law, there were the pending number of cases in the courts of Indian law were running into crores. And civil cases are such that if I file a suit today, probably the judgment would come in my grandson's time, hopefully. Now, with this kind of delayed justice and all this stuff, it brings jurisprudence. It brings I'm not quote unquote from the fraternity of law, so therefore my association is only generic. But I must thank you for having introduced our students, many of them who would be very fresh in the field, into this area. And I dare say, and I would like to tell all the students to please go listen to some of the YouTube uploads of Latika Vashisht, especially on feminism, on areas of the gender sensitivity, on areas where I'm not saying you're a feminist. I'm just saying that you are an amazing person with a lot of work that you've done on the area of women and law. So thank you once again for having spared the time and made this morning very interesting for all of us. And I thank the organizers for having made it possible for you to come over.
Absolutely.
And all the students for patiently and very keenly listening to your talk and putting up questions which were, I thought, very relevant. Thank you once again. Back to Ritu.
Thank you.
Thank you, sir. We are at the end of the session. I again thank you, Latika ma'am.
Thank you
for
so much for
interacting
having me.
with us.
Thank you, Dr. Vajpayee.
Thank you so much for sparing the time, ma'am. Thank you so much. It means a lot to us. Thank you. I'll be ending the webinar now.